Assalamualaikum warahmatullahi wabarakatuh. We are from group 6 that will be presenting about our topic, which is wasiyah as an instrument for Islamic wealth planning in Malaysia. Our group consists of 4 members, which is Abdullah Fahmi bin Rosli, Muhammad Iqbal bin Fauzi, Muhammad Anas bin Iskandar, and Shukri bin Abdul Latif. Our objective is to describe the concept of wasiyah. Second, to study about the wasiyah as an alternative instrument for Islamic wealth planning. And lastly, to explain about the application of wasiyah in Malaysia. Inshallah, my name is Abdullah Fahmi bin Rosli, and I will present first about our introduction about this topic. Before we dig deeper into the topic, I will explain a little bit about the topic first. One of the roles of wealth distribution planning and management is to keep assets from becoming permanently frozen after a person dies. As a result, managing and planning Islamic wealth distribution is a critical component of knowledge for ensuring the Muslim community's safety. There are various types of instruments that can be used in managing and planning Sharia compliant Islamic wealth distribution. According to the Quran and Hadith, wealth and estate transfer can be accomplished through wasiyah, waqaf, hibah, and any other means. However, the scope for this presentation will be limited to wasiyah and its role as an instrument for Islamic wealth planning in Malaysia. Inheritance is the disease legacy that must be managed efficiently in order to speed up the distribution to the entitled heir. In Malaysia, the number of estate record reported to be in area is generally high and growing. For example, it was reported in 2009 that the case of pending estate claims had reached 42 billion ringgit, with 1.8 billion ringgit of money hidden in the register of unclaimed money because the heirs had not settled. The issue of the heirs' attitude has been identified as the primary cause of Malaysia overdue estate issue. This includes a lack of understanding and awareness about the significance of estate planning. In that context, one of the things that society can emphasize is the importance of making a will. This mechanism will be able to facilitate and expedite the disposition of an estate following death. This can also serve as an supplement to the law of property division through Faraidh, preventing injustice and persecution of those who are entitled.
Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is Shukri bin Abdul Latif. My matric number is 2019219464. Alright, I want to present about concept of wasiyah. Okay, first and foremost, we go to the definition of will or wasiyah. Okay, will in term of language, okay, is derived from the Arab word which is wasa. Okay, the mean if orders, advice, promise, or property after death. Okay, Shafi'i jurists believe that language from the adjective wasa mean to connect or convey. Okay, essentially it represents the linking of a person positive deed during his lifetime with the reward that will be awarded to him after death. Okay, by definition, a will is an acknowledgement or pledge by a person to divide asset on death among non-heir and heir who are not able to inherit. Okay, next we go to the pillar of the wasiyah. Okay, first is testator or musi. Okay, testator or musi is a person who makes a testamentary offer during life. Okay, next is musalahu. Musalahu is the person who achieve a will made by a testator or al-musi. Okay, next we go to the al-musabih. Al-musabih is the property bequeathed must be mal hakiki, such as movable property and immovable property. It can also be as mal hukmi, that is benefit. Okay, last but not least, we go to the Sirah of Wasiyah, which is Ijab and Qabul. Okay, we go to the type of Wasiyah. First is absolute will. Okay, an absolute will is one that is made independent of and unbound by conditions such as those imposed by the testator and the bequeathed property. In the view of Shafi'i and Hanbali, the effect of this absolute will is that it will remain in force forever. Next type is conditional will. In a conditional will, the testator imposes certain condition. Fuqaha believe that the conditional imposed in a will are valid provided that they do not violate Sharia in terms of property approach to the condition imposed, and that such a will should be beneficial to the recipient, testator, and anyone else involved. So, a validly drafted will is binding on the testator, and he or she may accept or reject will it condition. Okay, this conditional will become void if the testator does not fulfill the conditions stated in the will according to Islamic law. Okay, general will. Okay, this is a type of will that is made to a general group of people, such as all the people living in a village or town. This type of will applies to all members of the local population, whether they are Muslim or not. Okay, lastly, we go to the specific will. Okay, a specific will is a will that is reserved for a particular party. Okay, the testator may compare the amount to be bequeathed with the amount that should have been given to one of the testator here when he or she testifies to a particular person. That's all for me. Thank you.
Hi, my name is Muhammad Iqbal bin Fauzi. For this section, I will explain about wasiyah as an alternative instrument for Islamic wealth planning. Okay, narrated by Al-Bukhari and Muslim from Prophet Muhammad sallallahu alaihi wasallam from his conversation with Sa'ad. Sa'ad said, "Should I give 2/3 of my wealth away in charity?" The Prophet said, "No." Sa'ad then said, "Then half, O Messenger of Allah?" He replied, "No, Sa'ad." "No." Sa'ad said, "Then a third?" The Prophet replied, "Yes, a third, and a third is a lot. Verily, it is better if you leave your inheritors wealthy than if you leave them poor and with their palms out begging from the people." Alright, from this hadith it said that if we want to give a charity such as sadaqah, wasiyah, we don't need to give all of our wealth. It complete if we just give it a third. The importance of will. Before determining any wasiyah, a person first need to have a will to do so. It is critical to write a will since the testator will decide who will benefit from the wasiyah. This will contribute a great trust to the person bequeathed from the testator. A will expresses and carries out individual wishes in a lawful way rather than relying on the state or other to make such decision on that person's wealth. Okay, normally in wasiyah it related to estate planning, which is a property. Okay. Estate planning is a fundamental financial planning. The reason is it one of the property or wealth that Muslims should protect. Property such as estate, house, land, and and as it was a big decision to choose who will inherit the property after a person died. It can protect Muslim property from falling into the hand of irresponsible people, or any institution will make a move to take advantage from it. For example, friends and relatives can spend a lifetime battling over the asset if there are no appropriate estate plan. Alright, next, responsibilities inheritance. As a financial planning instrument, wasiah also can be executed from continuing the testator commitment. For example, a testator need to choose who will continue managing the company when he passes away. As a Muslim, we need to prepare our dear self for death because it is a human being. Other than that, children also can be a subject to bequeath to ensure their safety. It is very usual for parents who have young children or have a minor children to be concerned about their child well-being and safety if anything happens to them. Alright, that's all from me. Thank you.
Assalamualaikum. My name is Muhammad Anab bin Iskandar. My card metric number 2019220594. Today I will explain the third objective, which is the application of wasiah in Malaysia. Okay, in Malaysia, when a person die, then the property he left can divide into three categories. First, testate estate, which is the property left by the deceased, which as a whole has a will. This category cannot apply to Muslim because Islam only allow will to be made not to exceed and the rate 1/3 of the relic property. If this is the case, then the will is only valid to the extent 1/3 only and not to the heir who are entitled to the inheritance. Although, however, if the heirs agree, then the will is considered valid. Okay. Second, intestate estate, which is the estate left behind the deceased without a will. This category can apply to Muslim and non-Muslim. In terms of its implementation, it is subject to whether the estate is property large estate, small estate or simple estate. Okay, and lastly, inheritance party testamentary and partly intestate, testate and partly intestate, which is the deceased left an estate were some testamentary and some non-testamentary. This category can happen to Muslim and non-Muslim. Okay, the next slide. In this section, discussion will focus on testamentary estate, either in whole or in part. If the deceased left a will, then according to the law in Malaysia, its administration is subject to the Probate Acts and Administration 1959, which is as 97. Okay, this means an application for a probate grant or a letter of administrative authority twinning can only be made in the civil high court only. Application for probate grant or a twin administrative power or attorney may be applied for by the executor named in the will the deceased, which is testator. If there is an objection or dispute about the validity of a will, then the question is need to be decided by the Syariah court. Okay, dalam kes ni, Salmah Zaidah binti Haji Wan Zaid lawan Nik Hasnah binti Nik Din dan seorang lagi pada tahun 2002. Payu ni mendakwa bahawa bapa angkatnya telah berkata kepadanya di hadapan kedua-dua responden bahawa dia ingin membina rumah. untuk diberikan kepadanya, iaitu kepada perayu tu. Sehubungan itu, bapa angkatnya telah menyediakan untuk pembinaan rumah tersebut. Walau bagaimanapun, rumah itu hanya boleh dibina selepas kematian bapa angkatnya. Okey, keputusan dilakukan oleh mahkamah syariah. Okey. Okay, the second point, the issue whether the words spoken by his adoptive father can be considered a will. The Kota Baru Kelantan Syariah Court of Appeal ruled that the word can be accepted as a will by way of kinayah, and the appellant is deemed to have accepted the will then when he managed the construction of the house and then occupied it. However, in the matter of the administration of the estate, whether a will either all testative or only partly testative, then the law provides that the Civil High Court has the power to issue order and not the Syariah Court as decided by the Court Federal. By the Court Federal Territory Syariah Appeal in the case of Jumaatun and Raja Delila vs Raja Hizaruddin 1998. Okey, bagi harta si mati yang beragama Islam, probat adalah perlu dipohon untuk pentadbiran harta yang dinyatakan dalam wasiat. Oleh kerana orang Islam hanya boleh mewasiatkan hanya 1/3 daripada harta pusaka, maka surat pewarisan kuasa pentadbiran juga perlu dipohon untuk memiliki harta yang tidak dinyatakan dalam wasiatnya jika nilainya melebihi 600,000. Sekiranya kurang daripada jumlah tersebut, surat pentadbiran kuasa ataupun pemilikan pusaka boleh terus dipohon di pejabat tanah. Okay, and the last point, as a result of the jurisdiction of these two different courts, Muslim needs to, in relation to two courts in matter of bequeathed property. The first through the Syariah Court to determine the validity of the will if a dispute arises. Secondly, through the Civil High Court to obtain probate for the administration of the property if the value exceeds Rm600,000. In this case, Muslims have to refer to both courts in will matter. This situation will involve additional time and expense to Muslim. Currently, only Selangor, Melaka and Negeri Sembilan have specific laws relating to the will of the Muslim. Syariah court in other states have to be guided by general provision, namely reference to Syariah law and dealing with cases with respect to will. This condition can cause there is no uniformity of law with respect to will applied in Malaysia. Okey, walaupun wasiat telah lama wujud dalam masyarakat Malaysia, namun masih terdapat kekeliruan dalam kalangan umat tentang pelaksanaannya. Okey, so salah faham ni yang wujud ni sudah tentu menyusahkan urusan pengurusan harta pusaka mereka apabila mereka telah meninggal dunia. Ini betul-betul berlaku. Mungkin kerana Malaysia belum ada undang-undang yang khusus yang berkaitan dengan wasiat. Okay, that all for me. Muhammad Anabi Iskandar. Hidup hanya sekali, justru biarlah berarti.
Alhamdulillah. In a nutshell, Islam does not deny that wasiah is one of the things demanded by Islam in property matters. particularly when it comes to Islamic wealth planning. Wasiyah is used to meet the requirement and desire of property owners. It should also be noted that an effective wasiyah is one of that. In addition to fulfilling its tenets and condition, appoint an executor who is responsible for carrying out the wasiyah. MAIS has been entrusted as an executor for a wasiyah in the state of Selangor, based on the Muslim Wasiyah Management Rules 2008, which is the first such rule regarding wasiyah in Malaysia. These rules were enacted to describe the procedure that MAIS, as a service provider and executor of a wasiyah, must follow. Furthermore, these rules serve as a guide for Muslims who wish to make a wasiyah in MAIS. It is proposed that states that do not yet have a wasiyah law or management rules take the lead in enacting such legislation. The Muslim Wasiyah Enactment of 1999 and the Muslim Wasiyah Management Rules of 2008 can be used as a starting point for this draft. However, as was done in the enactment of the Muslim Wasiyah Bill 2001, the Wasiyah enactment to be enacted must take into account the views of Jumhur Fuqaha in matters of wasiyah to heir. Even though the Islamic estate planning service has recently grown rapidly with a variety of products, there is still a lot of ground to cover in the future, and public education should be the top priority to improve the system of Muslim wasiyah administration. Sharia court should be given the authority to issue letters of probate, which is currently handled by the civil court. The Sharia court will need its own probate law for this. In matter of their wasiyah, the Probate and Administration Act 1959 must be amended to exempt Muslim from obtaining probate from the civil court to the Sharia court. Inshallah, that's all from us. Thank you for lending your ears.